case on this morning's docket. That is State of Kansas v. Amon Ruel.
Good morning. May it please the court. Meryl Carver-Allman, Capital Appellate Defender, on behalf of Mr. Amon Ruel and Chief Justice, if I could please have 3 minutes for rebuttal.
3 minutes is granted.
Thank you very much. As a brief summary of the facts in this case, my client was convicted of capital murder for a double murder and then also an attempted first-degree murder that happened in 2003. His case was appealed. He was sentenced to death. His case was appealed, and the Capital Conflicts Office had it at that time. They looked at the record and saw that there was just some pretty horrific ineffective assistance of counsel. Did a Van Cleve remand, kind of skipped the direct appeal process, bifurcated the process, and eventually between the trial court and this court, my client was ordered a new trial. And actually his trial attorney was eventually disbarred also. So basically from the instant that he was awarded that new trial, he started raising this double jeopardy issue, raised it several times all pro se. And then eventually, after losing that motion several times, he decided to plead no contest and just try to appeal the issue. A few weeks after the plea hearing, I think maybe as much as a month, he decided to withdraw his plea. That motion to withdraw his plea was denied, and he was sentenced to approximately 39 years without possibility of parole, and that's kind of where we are today.
There was one other procedural fact,
Sure.
not in this case proper, but he also filed an original action for habeas corpus. Didn't
He
Did
did.
not?
That is
that was
correct.
pending at the time he entered his plea and was sentenced in this case.
Absolutely. And that was dismissed basically, I don't know, within a few months after he was sentenced in this case also.
Okay.
So just as an initial point, this is a pre-sentencing motion to withdraw plea, so we're under the good cause standard, and I believe that the state has misstated the standard of review in their brief. They say that whether good cause exists is a question of fact reviewed for substantial competent evidence, and that's citing a case called Anderson, where there actually was kind of a factual dispute below about what the attorney had told the client, and the judge decided to believe the attorney and then based the good cause finding on that. So I don't think that really the substantial competent evidence standard has much to do here, where all the facts are on the record. There's not really factual dispute in this case. So I would argue that we are under good cause on the motion to withdraw a plea. That's reviewed for abuse of discretion, but we are arguing that there was a mistake of law here. So that would be sort of an automatic abuse of discretion, if you will. So I guess I don't think anybody disagrees that my client's plea waived his double jeopardy issue. Double jeopardy, even though it seems jurisdictional, is not a jurisdiction issue proper. And that's part of the problem in this case, is that they were throwing a lot of words around like habeas and jurisdiction and double jeopardy, and not really nailing down the meaning of them very precisely. So in the plea hearing, for example, the court says that the plea would make his efforts for dismissal go away. But then his attorney says, well, he always has a right for habeas corpus. And at that time, as Justice Beyer has said, he had a habeas corpus petition on the double jeopardy issue in front of this court at that time. So when we're trying to understand what he understood at that time, I think that we have to take into account that they were throwing around some language here pretty fast and loose. And the court, I think, initially probably said the right thing at the plea hearing, but then kind of got talked out of it by defense counsel's advice. And I think, there's definitely evidence that perhaps the district court and trial counsel were not aware that Mr. Amon Ruel was actually waiving the double jeopardy. I don't think that they were purposely trying to mislead him necessarily. I think that everybody below just wasn't aware. And I think if you look at the sentencing hearing, that's really, really evident when the court goes to consider my client's motion to withdraw plea, because he says, I think depending on how you count it, 4 to 5 times, what is your problem here? You can still appeal this issue. If we had gone to trial, you could appeal this issue. You pled, now you can appeal this issue. That's what you want to do, is appeal this double jeopardy issue. There's no problem with you doing that after your plea. And the court, again, said that in different ways 4 to 5 times, even told him, your case could go all the way to the Supreme Court with this issue, when in fact he had just completely waived the issue. There was no way he could raise it further. He was done. Getting into the Edgar factors a little bit, the first factor is competent counsel. And here we're arguing not that his trial attorneys were generally incompetent. I think they're both fine attorneys. But just in this particular piece of advice, you can have a great attorney, but they can be wrong. And if it substantially affects the advice that they give to their client on a key point, then that's ineffective still. So that's basically what we're arguing under competent counsel. And again, we are under the good cause standard, and this court has said that lackluster advocacy is enough under that standard. We don't have to prove, full and proper ineffective assistance of counsel there. So I think we've met that burden there. And second, and it's kind of two sides of the same coin here, and the second factor is whether my client was misled. We're not arguing, as the state points out, we are not arguing that he was coerced or anything like that, but just that he was misled by the district court's statements to him. And partly, even at the plea hearing, my 5-year-old son knows the difference between maybe and no. And the district court at the plea hearing was saying maybe, maybe you can raise this. And the answer isn't maybe. The answer is no in this case. He could not raise that issue further. So that was misleading on the part of the trial judge. And again, probably not intentionally, but I think that is maybe not a point of law that everybody is aware of all the time.
Is there a distinction between, because I thought, as I read it, that the judge wasn't saying so. And in fact, I think the judge went to some effort to say, you can take this action, but I don't want you to have false hopes that you are going to be successful. I think, and isn't that a valid distinction, that nobody can stop him from filing appeals or habeas actions, but nobody was guaranteeing him that any of those, but I think they were trying to make it clear to him that he wasn't going to be successful on those.
I think that the judge initially might have said that, and like I said, I think counsel's statements kind of talked him out of it. Because the judge said, the judge said what you said. I agree with you that was the first statement out of the judge's mouth. But then, he comes back and he says, I don't know what those outcomes might be. I don't know for sure.
Well, and isn't that right? As Justice Luker just pointed out, I look at this record and it's hard to fathom a more cautious and more informed plea colloquy with the court and the counsel and the defendant, and then you have the signed waiver that goes over the rights also. But isn't that, how could the trial court judge say, no, this cuts it off? Your client could always bring an appeal raise on it, and there's no guarantee as to what would happen. What's wrong with saying something like that? Why is that wrong?
I disagree very strongly with the idea that there's no guarantees as to what would happen. Frankly, if my client hadn't filed a motion to withdraw plea, with the issues in this case, I can almost 97% certainty say this would have been a summary disposition form. There are no issues that he can, viable issues that he could raise. He was cutting it off, and they said and you mentioned the plea agreement, and I'm glad you did, because they said in the plea agreement that he can appeal jurisdiction. And in Gilbert, I think, which is the case I-609 a few weeks ago, and I understand that's an unpublished Court of Appeals case that's not binding on this court, but the same thing happened in Gilbert, and Gilbert was actually under the post-sentencing standard even, and the Court of Appeals said, yeah, that's confusing because speedy trial and jurisdiction could be, those are kind of the same thing. And we've got the same thing here with double jeopardy. If you're not a lawyer, those sound an awful lot like the same thing. And I understand, my client is smart. Don't get me wrong there. But that's an awful fine point for somebody who hasn't been to law school to understand. And then the third Edgar factor, I think I've mostly made my points on that, except that I do want to say that the underlying merits of the appellate issue are irrelevant, so it doesn't really matter in this case, and I'm offering no opinion here today either way on the underlying merits of Mr. Monroe's double jeopardy issue. The point of the thing is he had the right to file an appeal on that issue, and he waived that right, and he did not do it knowingly or understandingly. You know, whatever we think of the underlying merits of the issue, whatever the state thinks of the underlying merits of the issue, that just really does not matter under Edgard. We're not here to decide that much today.
Any further presentation?
Not unless the court has questions.
Any more questions? Thank you, counsel.
Thank you.
Good morning. May it please the court, the state appears by Assistant District Attorney Jody Litvin. Our position today is that the defendant, his claims that he was misled and his claim that the district court abused their discretion when it denied the motion to withdraw a plea, we disagree with that. Our position is that the district court used the correct legal standard when he was in the motion to withdraw a plea hearing and addressing defendant's pre-sentence motion to withdraw a plea, and that because he used the correct legal standard, this wasn't an error of law and not an abuse of discretion. Starting from the ruling on where the district court was addressing the motion to withdraw a plea, the district court correctly stated this is a pre-sentence motion to withdraw a plea. We use the good cause standard here, addresses the Edgar factors, addresses that they are non-exclusive factors. I think even throws out the other factor of actual innocence and makes some reference that although the Edgar factors are benchmarks, the court was not limited by those factors. There was a correct, the court started out from the beginning with the correct legal standard. So I think that's the first issue that the state has with even getting to address the Edgar factors. We have to start with, did the court start with the correct legal standard? And our position is that yes, it did. If we look at the Edgar factors, the first one is competent counsel. And again, I agree with the district court's determination that counsel represented the defendant adequately, competently, pursued all of the motions and got them to a resolution, and that counsel was competent in this case. So I don't know that there's a big issue with the first Edgar factor. As to the second Edgar factor...
But does counsel not have an obligation to make sure his client is very clear about the right that's being waived? And do you agree with your opposing counsel that if anything here, the counsel kind of muddied the water?
I don't agree that they muddied the water. What I think counsel was trying to do was say that he's not waiving every right to appeal. He has limited rights to appeal. And I think he was trying to clarify that he still has the right to appeal on jurisdictional basis. And what I think they were alluding to, since he did have an original action with this court, that he had that option for a habeas, or maybe alluding to a 1507, a collateral attack, that they always have those options. So I don't think that was misleading. I think that was trying to clarify that he has those certain limited appellate rights. And I think that's important too, is because those were stated in section 14 of the plea agreement, which I don't think that's ambiguous or confusing at all. So I think that counsel was just trying to clarify rather than muddy up the water there. And I think it's important to note too that they had a discussion. I mean, he stopped the district court at that point. He had a discussion with counsel and they conferred, and then there was no evidence presented later as to what they said. So in that motion to withdraw a plea hearing, he didn't present any evidence that district court or counsel told me right then, you can absolutely appeal this double jeopardy issue, or didn't provide any other evidence of what was said there, or anything talking specifically about the double jeopardy issues. So there was no evidence before the court at that hearing to support his argument that he was misled about that issue. So I don't think it muddies up the water, but it clarifies his appellate rights. And then going into the next section of where the district court said after that, okay, I want to talk about that because I don't know what this court, the Supreme Court, is going to do with your habeas action, and I don't want to give you any false hope that you can continue to have that action after we accept your no contest plea today and you're found guilty. So I think he really wanted to hammer home the fact that there was no guarantee that he could even continue his habeas action at that point. There was no allegation that he was physically coerced or threatened or anything like that. So as far as the misleading, the state would just refer the court back to the time in which the plea was entered. And the judge made several statements about if he had gone to trial, he could challenge the conviction, he could challenge any rulings that the trial judge had made leading to the conviction, aspects of sentencing, or any other rulings that were made in the district court proceeding. And if the court accepts your plea and you're found guilty, you would waive or give up that right. Do you understand that? And the defendant said, I understand. And that was before they went into the whole, specifically talking about his appellate rights. And the district court makes a very strong statement of all of the things that you have raised. He recognizes the right that the defendant has tried to stop the trial and has multiple efforts to stop the trial, including with this court in his original action, and filed other types of pleadings for dismissal with this court. But if you're entering a plea today and the court accepts it, you're found to be guilty, all of those proceedings or motions that you have filed would be resolved and could not be raised again. Do you understand what I'm saying? I think that's very clear by the district court. I think defense counsel tries to clear that up even further, and there's further clarification by the court as to this court's habeas ruling. So I don't think that that's in any way misleading by either the court or counsel.
Well, Counselor, would you agree that if a defendant has made multiple attempts at establishing double jeopardy in the trial court and is led to believe that a plea of guilty would not preclude taking that issue to the appellate court, and believes that I can plead nolo contendere and still appeal to the higher court, that would be less than a knowing voluntary plea, that would be good cause to withdraw?
I think what it all goes back to, Your Honor, is the fact that was he misled at the time?
No, would you agree that would be good cause if someone entered a plea not knowing that the issue they've been pursuing was precluded, that with the understanding in their mind, right or wrong or not justified, but the understanding that he could nevertheless continue to pursue his double jeopardy argument, that would be good cause to determine it wasn't a voluntary plea?
I don't believe it would rise to the level of good cause, no. I believe it would go to one of the factors, the Edgar factors, the third factor, and that could weigh against the finding that he was entering a knowing and voluntary plea, but I don't believe in and of itself it is good cause. I think
It doesn't matter? It doesn't matter if there's a misunderstanding?
I think you need to look at the other Edgar factors as well and weigh those. Because what if his counsel had said, you can't, you absolutely cannot. And in his mind, he still thought, yes, I can.
We're talking two different, my question was, would that misunderstanding constitute good cause? You're arguing that it was an unjustified misunderstanding, that it's incredible to believe that he would have misunderstood. That's what you're arguing. But what I'm asking is, if that understanding was there, doesn't that impact the voluntariness of someone's plea?
I think it does impact the voluntariness, but I don't think in and of itself that's good cause alone. I don't know that I have anything else to go to for the misleading factor. And then as far as the knowing and voluntary plea, again, we would just go back to the very lengthy plea colloquy that was had in inquiry by the district court. I think the district court was very cautious and thorough in the plea colloquy and the inquiry to both defense counsel and the defendant, and he provided answers that reflected that he understood the consequences of his plea, that he understood all of the rights that he was waiving, and stated several times on the record that he could help more people with a life sentence than a death sentence. So I think it was clear that he understood the benefit that he was getting from the plea in regards to the rights that he was waiving. And then I just want to hit on Gilbert real quick. In that case, I think it's distinguishable here and doesn't really help the defendant's position in that that was a summary dismissal, and what the court had decided in Gilbert was that he gets to come back and have a hearing to determine whether his attorney had incorrectly informed him that he could appeal those issues, whereas here the defendant had a hearing and had the opportunity to present all of that evidence, and it was ultimately denied by the district court. So the fact that the defendant here had a hearing, I think, distinguishes that from Gilbert, where they were saying that this was something that should have just been summarily denied. I do want to throw in the harmlessness error just as a backup, I guess, to my argument that if this court finds us that counsel or the court misled the defendant in any way, that this court could still find that the error was harmless because the decision complied with the requirements of the statute in the motion to withdraw a plea statute. So with that, I don't have any further presentation.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
We reserve 3 minutes for rebuttal.
First of all, just as to what counsel said about Gilbert, I believe, just from my quick scan of it there, I think counsel is misreading that case. And I think this part of Gilbert is wrong, actually, because what they remanded for in Gilbert was to determine whether his issue that he wanted to withdraw his plea to appeal had merit, whether the speedy trial issue had merit. They were going to go back and count days, I'm assuming. So I think that part of Gilbert is actually wrong. But they found that based on, and basically, I mean, in all of these plea withdrawal cases, we're looking at kind of three things. We're looking at what the judge said during the plea colloquy, we're looking at advice of counsel, and we're looking at the plea agreement. And frankly, I think to the extent that there is not clarity in particularly what Mr. Aller told the defendant, because, you know, we have this, and this is at the plea hearing, you know, the court made its statement that, you know, maybe you won't be able to raise this. And then the defendant conferred with counsel, and then Mr. Aller said, well, he can still do his habeas. He can't appeal a conviction, but he does have essentially other ultimate appellate rights. So I think to the extent that we need to clarify Mr. Aller's statement on that, we have a method for that. It's a method that Kansas courts use a lot in plea withdrawal hearings, and that's we remand it to see, okay, what did you really tell your client during that exchange? So that's, I mean, I think that there is enough in this record that my client should be allowed to withdraw his plea. If the court has some doubts about that, we can do a remand hearing. We have a procedure for that. Also, I think as to counsel's harmless error argument, I don't think that that's possible in this case. I don't see how that's possible. Either this is fine or it's not fine. There's no, all of this happened and he was misled and he misunderstood, but somehow it was harmless. This issue was, I don't think I can overstate the importance of this issue to my client. This issue is very important to my client. To this day, this issue is very important to my client. And you know, morally, I don't disagree with him on the merits of it, frankly. But you know, he was induced, our position is that he was induced to plead with the understanding that he could appeal that issue. That right was taken away from him when he pled, and therefore his plea was not understandingly made, and this court should allow him to withdraw it.
And if he withdraws, there's no nothing to stop the state from reinstating the capital murder charge?
There is not, that I'm aware of.
Could I bring this full circle and go all the way back to where you started, which is the standard of review?
Sure.
And you'd made the argument that the district court applied the wrong legal standard. The state...
I disagree with that. I don't think I'm arguing that.
Okay. then clarify for me. I understood you to be arguing this is abuse of discretion, but one of the ways the district court can abuse its discretion is by applying the wrong legal standard.
Yes, by a mistake of law, in that the district court did not understand, and I think that the trial attorneys did not understand also, that jurisdiction, as
Okay,
they were
well,
using
that's
the
my
term,
question.
did not include double jeopardy.
When we talk about a motion to withdraw a plea, and we talk about what legal standard should be applied, the state is arguing the district court applied the correct legal standard. They applied the good cause standard, looked at the appropriate factors. That's the legal standard that governs the district court's exercise of discretion. Do you disagree with that?
I don't disagree with that.
Do- So then how are we not in old-fashioned abuse of discretion review?
The court abused its discretion because throughout the sentencing transcript, the sentencing transcript, the plea withdrawal hearing transcript, same thing. The court kept saying, you can appeal this.
But why does that matter?
Because it matters as to whether the plea is knowing and voluntarily made. I mean, it's a mistake of, and I see what you're saying. We're kind of 2 steps away there,
Yeah,
but that still
right.
doesn't make it any less mistake of law. And that was clearly the basis of the district. I mean,
Well, but even if, let's just grant for the purposes of argument that you're right, that there was a misunderstanding or mistake of law on that question. I'm just having trouble connecting that with the legal standard that the district court uses to decide whether or not to permit the plea to be withdrawn.
let's see if I can help. I have it all straight in my head, but whether I can get the words out will be a different story. Okay, the Edgard factors are what we look at in evaluating a motion to withdraw a plea. But, I mean, that doesn't mean, and frankly, even Edgar says these aren't the only factors we look at. And so I think that mistake of law as to what jurisdiction meant in this case plays into those factors. I guess it's kind of
You are really
a
making,
little A under those factors.
You're saying no reasonable judge could have reached this because no reasonable judge would have made that mistake. That sounds to me more like what you're saying, because you started out arguing basically a de novo type review.
And that
But
it's
really
hard
not de
because
novo review, is it?
it is not de novo review, although I think courts have treated it a bit like de novo review when there's abuse of discretion based on a mistake
Agree,
of law.
and that's what I'm trying to parse out here.
Okay. I mean, and I think there's certainly precedent for this court to do the same in this case based on
But I think
what
we've
courts have done in the
established
past.
that when it comes to the legal standard that applies in a motion to withdraw a plea, we've established the district court applied the correct legal standard.
The district court applied the Edgard factors. I cannot agree with you that the district court applied the correct legal standard.
In evaluating one of the factors.
Exactly.
Contained
Thank you,
within
Justice
that
Breyer.
Edgar factor is the mistake of law.
Exactly.
Anything else we can do to help your argument?
I don't think so.
All right. Any further questions? All right. Thank you, counsel.
you.
We thank you both for your arguments this morning. Court will take this matter under advisement.